All right, folks, thank you for joining us today in the very last edition of our Protecting Your Legacy One Lunch Break at a Time, our Lunch and Learn series, talking about different estate planning topics. Today, it's just me. My name is James Greenwood. I am an attorney licensed here in Iowa and Illinois, and we're just going to talk through some common estate planning myths. And, I think if you've listened to us for the last little while, some of these are going to feel obvious to you, right? If you've got, if you've listened to, the topics that we've covered and what we have said about things that are frequently seen in estate planning situations about who's going to get what, how things work. We are always interested in helping to identify how things are supposed to work and make sure that those things are clearly identified, laid out, and that they are in fact going to work in the scenario specific to our clients' wishes. So let's talk just a second about some common estate planning myths. Let's start with the basics. And that's the first thing that we really have to talk about is the distribution plan. People repeatedly come into my office and they say, hey, I've got this plan and I don't really need anything other than a power of attorney because my spouse is supposed to get everything. Well, if we have that conversation with them, we find out, oh, there's a spouse, the spouse has some kids, they have some kids. But it's pretty clear that they want the spouse to get everything. And this is a mixed family. It's, they may have been married for years, but what's called the intestacy statute in each state is going to drive the conversation about, well, what actually happened with that and who gets what. When we have these scenarios where somebody maybe wants something aligned differently than perhaps they have stated, we're always interested in having these first tier conversations about, hey, what are you looking to get done? What do you want to have happen with your stuff? And when we have those conversations, a lot of times we find out that there's no will in place, there's no plan that clearly delineates who's going to be in charge. The other presumption that we see a lot of, and that's a little bit of a myth, is that everything will be managed by somebody's specific child just because they said that child verbally told somebody that child was supposed to manage everything. It might not be the case. There are a number of things that can change that. And again, that's something that's got to be delineated clearly in a will if you want to make sure that it's going to happen. And even then, there can be challenges to that will. So it's important to have those conversations. And that's really priority one in our list of things to really emphasize. Unless you've got a will and you've talked to an attorney, made sure that everything's valid and everything's on the up and up, it's not uncommon to have some sort of problem with distribution. So that's item one that I just wanted to make sure that we address today. Again, as always, this is an educational podcast. It's not intended to be legal advice. You should always consult an attorney in your state regarding, or at least licensed in your state, regarding what your wishes are for your estate planning. Make sure that you talk to them, clearly articulate with them what you're looking for. And most good estate planning attorneys are going to have a pretty clear set of tools that they have that they can utilize to assist you. All right, so let's turn to a pretty common myth that we see, and I think we've really kind of debunked some of this. Estate planning is only for the wealthy. When we have people who even have limited means or limited assets, estate planning can be useful, especially if there is a child who perhaps shouldn't inherit everything for any number of reasons. That child could be disabled, they could have a drug problem, they may have some sort of other issue that if you gave them, even a few $1,000s could create some sort of problem for them. And so where we have those opportunities to make sure that the child is protected, or that maybe a loved one gets what they need to survive, those are great opportunities to do estate planning where mixed families are involved or where perhaps people have non-traditional families. Those are, again, great places to have a conversation around estate planning. It's very important to make sure that you have that plan in place. Even if there are just children and a spouse, oftentimes, depending on the intestacy statute, there may be substantial changes that need to be made to the way things work in order to make sure that what somebody wants to have happen actually happens. So always something to keep in the back of your mind. Some people, I hear it frequently, oh, I'm too young, I don't need a will. Again, nobody knows when they're going. If somebody comes up with a clear picture of when you're going to die, when everybody's going to die, and has a clear plan on that, you let me know. But I've never met anybody who had a very crystal clear, picture on when each person in their family was going to die and what the consequences of that were going to be. I think young folks, oftentimes just assume that everything's going to be kosher and fine. Frequently it is, but maybe you don't want your sibling to be making medical decisions for you. Maybe you want a parent to receive everything instead of it going to, your little brother or sister. Maybe you don't want your kids to get anything directly, or maybe you need to name somebody who's going to take care of your kids. All of these things are things that will be impacted by a good estate plan, and are things that we should absolutely have that conversation about with our attorneys in the state that we are in, right? So make sure that you have those conversations at a juncture soon with somebody who actually knows what they're doing. An attorney is a great resource for this. Each one, somebody licensed in your state. A will is enough. I hear that all the time. I'm just here for a will. I get it. People are thinking, oh yeah, I just need the will. I don't need anything else. And frequently that is the case. But that's not always the case. And things that trigger those more complicated conversations from family issues, it can be types of property that are owned. It could be business interests. It could be any number of other things that might trigger a need to have a conversation, at the very least, about how do we plan for the future. And so, will frequently doesn't may not cover everything, or we've had incorrectly executed wills in the past where we've seen people go out and draw up a will and think that they're executing it properly, but it turns out it's not properly executed in the state that they're executed. So each plan needs to have all of the appropriate documents, and making sure that those documents are properly executed, that they cover what needs to be covered, that they otherwise address anything that needs to be addressed, is incredibly important. Well, the state will take everything. That's a big myth. I hear people say it all the time. The state's going to take all my stuff, or the state's going to do this, or the state's going to do that. The state very rarely gets everything in a probate. More often than not, we are able to find heirs, and we are able to distribute assets. And frequently when people die without a will, it creates really challenging situations where maybe they didn't anticipate that their third cousin once removed is going to get something. And so it's important to keep in the back of your mind, what exactly you want, especially for those who don't have children. Those estate plans, people who don't have children, are probably some of the hardest estate plans we do, because there is an incredibly deep introspective approach that has to be taken by our client regarding what their values are, what they want to have happen. There's no societal default for folks without kids. And so when we're making those plans, it's incredibly important to make sure that you think through carefully with your attorney, with your financial advisor, with your friends, what are your values? What is it that drives from day to day? And oftentimes, even with people with children, we have people who make large charitable gifts sometimes at their death. And if your values involve a church, if your values involve schools, if your values involve charitable giving, those approaches may be appropriate. So certainly something that that we should be keeping in mind. Sometimes we hear, oh yeah, there's no will, so there's no probate, right? Well, not really. Again, less frequent, but we hear it sometimes. No will often just means that the intestacy statute takes over. There's going to be a probate. There's going to be potentially a probate or potentially other proceedings that have to happen. It just creates extra work for the attorney, and anytime you have extra work for the attorney, that's both greater expense. So, this will sound a little counterintuitive coming from an attorney, but there's no reason to give extra money to the attorneys. I love, I really love it when we have a well laid out trust. That my favorite thing ever is when there's a well laid out trust. There's a clear set of succession as far as the trustee goes, and there's very little I have to do. Nothing makes me happy with that scenario. So, okay. And then estate planning only impacts you after death. That is absolutely untrue for anybody who attended any of our presentations where we talked about powers of attorney, trust planning. Trusts can absolutely have assets that are utilized for your benefit while you're alive. Powers of attorney can absolutely have control provisions that allow somebody to manage your stuff even while maybe you're overseas, or maybe you are needing somebody to make medical decisions for you temporarily. Those conditions are all while you're alive, and so it's certainly incredibly important to think about what exactly it is that's driving. And then the last thing I just want to make sure that we address today, and it's a pretty straightforward piece of information, is once I create the estate plan, I'm done. Once it's created, I never have to look at it again. And that could not be further from the truth. I just had the opportunity to talk to some longtime clients, and when things change, when a parent passes, when a child gets married, when a child has children of their own, maybe you have another child yourself. Each time you have that happen, it's important to have a conversation, at the very least, with an attorney, again, licensed in your state. Depending on how the will was drafted, it may have a very serious impact, especially with additional children of your own, or the death of a parent or family member who was supposed to get something, even by default, upon the death of somebody else, inside of the estate plan. And so there can be major implications each time there's a change to your family structure, each time you inherit a large amount of money. As we discussed many times, there are people who live in states that have a state for inheritance tax. Every time one of your family members moves or changes states, estate tax may not get them depending on which state you're in and which state they're in, but inheritance tax is a real thing, and it might depending on where they move. So it's important to have those conversations fairly frequently with your attorney. We always suggest at least once every 2 years, just to do a quick check-in. Worst case scenario, you end up with somebody who says, "Oh yeah, I don't have anything that's really changed, and I don't really need to do anything." As an attorney, that's fine. The majority of our estate plans are pretty durable. There are frequently, people who come in and we look at the estate plan and we're like, we could update this if you want. There's no particularly good reason. Our plan, as currently stated, still does what you want it to do. It still works just fine. But there are other times where we take a look at things and we say, well, it's been a while since this was done. There have been changes to law. There have been changes to the way that your family is structured, and maybe the way that this works doesn't quite align with what you want. So each time there is that change, you should be talking to the attorney. Again, licensing the state where you are. I'm gonna wrap it up a little early today. My name is James Greenwood. I'm an attorney licensed here in Iowa and Illinois. If you have any questions or concerns about today's presentation or the topics, I am in fact responsible for the content of this presentation. You can reach my office at 855-528-6022, and that's 855-528-6022. Thank you so much. Have a good day. Goodbye.